Samnikai. My name is Myra.
My name is Sanjun.
My name is Jessie. My name is Litong.
In this video, we are going to discuss on the law of child marriage in the UK and in Malaysia. Child marriage is a formal marriage and informal union where one or both parties are below the age of 18. UNICEF's stance on this matter is that the minimum legal age of marriage is 18 without any exception. However, in the UK and in Malaysia, child marriage is still legal to a certain extent. Let us look into the current law of child marriage in Malaysia and in the UK now.
The Marriage Act 1949 is an act of Parliament in the United Kingdom which regulating the marriages of infants and girls. According to Section 2, a solemnised marriage which is under the age of 16 will not be considered as valid. This rationale is set out in the case of Park and Park 1951, which the judge stated that it is considered socially or morally wrong that the child with this age have stresses or responsibilities, sexual and should be free from sexual freedom of marriage and also the physical strain of childbirth. Whereas Section 3 stated that the age below 21 should have parental consent.
The Forced Marriage Civil Protection Act 2007 enables the victim to seek the forced marriage protection order against someone forcing them to marry. However, this act only provides civil remedies. Later in 2014, the Anti-Social Behaviour, Crime and Policing Act 2014 make it a criminal offence for child and forced marriage.
In Malaysia, there is a dual legal system. Issues related to marriages are either dealt with in the civil courts for non-Muslims or the Sharia courts for Muslims. In July, Deputy Women, Family and Communities Development Minister Hannah Yeoh announced that a shocking amount of 14,999 child marriages were recorded between the year of 2007 and 2017, with 10,000 of those being Islamic marriages. In Malaysia, the legal age to marry is different for Muslims and non-Muslims. According to Section 10 of the Law Reform Marriage and Divorce Act 1976, the legal age to marry for non-Muslims is 18. However, those who wish to marry between the ages of 18 to 20 are required to seek permission from their parents to marry. It is possible to get married at the age of 16 if permission from the State Chief Minister is obtained, but any marriages below the age of 16 is not allowed. For Muslim, the legal age to marry is 18 for boys and 16 for girls. Those who wish to marry below the age of 16 are required to seek permission from the Sharia courts.
It is possible for individuals below 18 to get married, even though Section 2 of the Age of Majority Act 1971 states that 18 is the age of majority. But Section 4 sub A states that it doesn't affect one's capacity to marry. The law in Malaysia is confusing because civil courts are more inclined towards Section 2, whereas Sharia courts are more inclined to Section 4 sub 2, which allows individuals below 18 to give consent in marriage-related matters. Although she is young, but I think she can do well.
Hi. So here's the money.
You need to be vanished. No!
I'm too young to have a baby. I have to get rid of this baby.
There is an ongoing international forum regarding child marriage going on right now. Let's go in and have a look. As we all know, the issues on child marriage, anyone has any suggestions or want to raise any issue regarding on this?
Child marriage indeed is a very serious issue. As from the report from UNICEF, found out that there is 2,000 statutory rape cases, 780 were cases of premarital sexual intercourse, of which is 62% involved children aged 13 to 15.
Indeed, girls who married to an older man will have this intensifies power imbalances in their relationships, such as subordinates to their husband and families. Situations when a child is forced to be married to a man is believed to have not consented to the sexual intercourse with their husband.
So, to what extent does the UK law provide protection to these victims?
Okay, so in UK, according to Section 1, subsection 1 of the Sexual Offences Act 2003, sexual intercourse in a child marriage is deemed to be rape. This is because the girl does not consent to the penetration of penis by her husband, and her husband agreeing to this child marriage does not reasonably believe that the child consented to this sexual intercourse. In reference to the definition of Section 74 in Sexual Offences Act 2003, the two main focuses for consent is the capacity and freedom to choose by the consent giver. So, after a child being married to a stranger, she's worried that she will be beaten up or being chased out from the house. With this sort of external coercion, there is no consent in reference to Section 74 of this Act.
In addition, Section 5 to Section 8 of this Act stated that any sexual intercourse with the child under the age of 13 is a statutory rape. As for Section 9 to Section 13, it governs those who are 13 but under 16. The explanatory notes read, whether or not the child consented to this act is irrelevant.
With being illegal to get married at the age of 16 and below, UK has provided many protections from being raped for those below 13 and 16. What about those that are forced to get married at the age of 16 and above?
Okay, for these cases, those who are married at 16 with parental consent or those as 18 and above, they can charge these cases with marital rape. Ever since the landmark case R&R, marital rape has since to be recognized as a crime. Even if a child is married at the age of 16 with parental consent, it is still deemed as a rape if she did not consent to this sexual intercourse. Besides, child marriage has a strong correlation with sexual exploitation. This is governed by Section 47 to Section 50 of the Act, which provides that if a person commits an offence by initiate any sexual services in return of any financial payment, and the victim is below 18, it is a crime.
What about Malaysia? Do Malaysia provide this protection to those young girls?
Yes, when these girls are married off, they are forcibly exposed to sexual acts before they are physically and emotionally ready for it. These sexual acts amounts to the crime of rape under Section 375 of the Malaysian Penal Code. Children below the age of 18 are considered to be below the age of consent. Hence, they cannot be said to have consented to the sex. This is in accordance with Section 2 of the Age of Majority Act 1971, which states that 18 is the age of majority and any persons below that age is not able and lacks the capacity to make certain decisions. For Islamic marriages that occur below the age of 16, Section 375 subsection G provides that no matter the circumstances, with or without consent, there is rape committed when there is sexual intercourse with a person that is below the age of 16 years old. Some other laws in Malaysia that provides protection for these acts include Section 377C, Section 377CA, Section 377D, Section 377E of the Penal Code, Section 31 of the Child Act, as well as Section 11 and Section 14 of the Sexual Offences Against a Child Act.
Since there are so many laws in place to prevent such act, why does child marriage still happen so frequently in Malaysia?
The sad reality is that young girls are often forced to marry men who have actually raped or sexually assaulted them, and the marriage is used as an escape route for those who have actually committed crimes to escape criminal convictions. One notable case is the one in 2013, where the Sharia courts approved the marriage of a 40-year-old man who had committed rape to a 13-year-old victim. Since marital rape is not a crime in Malaysia, child marriage exposes these young girls to dangers of being raped again.
What about those who have sexual intercourse as statutory rape below the age of 16?
When young couples are faced with unwanted pregnancies after committing premarital sexual intercourse, usually both families will come to an agreement on the marriage in order to prevent the young boy from being charged with rape under Section 375 Section G of the Penal Code.
As mentioned, rape or unprotected sexual intercourse can lead to unwanted pregnancies, which will lead to the issue of abortion. So globally, teenage pregnancy accounts for more than 90% of all maternal deaths, and research has shown that girls aged 15 to 19 are twice likely to die during delivery than women aged 20 to 24 due to their immature bodies. Therefore, abortion will normally be carried on to an eliminate the risk to a pregnant woman?
In UK, there is a statute which is Abortion Act 1967, as amended by the Human Fertilization and Embryology Act 1990, that govern abortion. The most important requirement of abortion is being that two doctors had a stake in good faith, that continuation of the pregnancy would involve a risk greater than if the pregnancy were terminated, of injury to the physical or mental health of the pregnant woman, or to any existing children of the pregnant woman.
So does abortion constitute to murder in UK?
Yes, abortion is a murder because it involves killing of an innocent human being is wrong, even if that human has not been born. The law of murder is set out in common law. The legal definition in murder from the UK Parliament is the unlawful killing of human beings. Life begins at conception, so unborn babies are humans, beings with the right to life. For the purpose of Section 58 and 59 of Offences Against the Person Act, which we call it as OAPA, and any rule of law relating to the procurement of abortion, anything done with intent to procure a woman's miscarriage is unlawfully done unless authorized by Section 1 of the Abortion Act 1967. Upon fertilization, a human individual is created with the unique genetic identity that remains unchanged throughout his or her life. This individual has a fundamental right to life, which must be protected.
But how to prove that the woman's miscarriage is unlawful? In the case of Natalie Towers, she bought abortions pill from the internet to induce the miscarriage while she was 32 to 34 weeks pregnant. So what are your opinions on this?
Under this area of law, it was seem that unclear with the definition of the good faith of a doctor. It's only legal for abortion up to 24 weeks of pregnancy and signed off by a doctor. If there is a risk of mother's life or in cases of fetal abnormalities. In the case of R&B British Broadcasting Corporation ex parte Pro-Life Alliance, Lord Justice Law said that many doctors of a woman that having an abortion, a state of affairs which is said to allow this situation of de facto abortion on demand to prevail.
So how frequent does teenage abortions happen in Malaysia?
In Malaysia, on average, about 18,000 cases of teenage pregnancies are recorded each year, and about 50% may end up in abortion.
Is abortion a crime in Malaysia?
Yes, under Section 312 of the Penal Code, induced abortion is illegal. Medical practitioner or mother who voluntarily carries out the abortion of a fetus would be penalized unless a medical practitioner registered under the Medical Act 1971 acts in good faith. For example, in situations where the continuance of the pregnancy would involve risk to the life or injury to the mental or physical health of the mother.
In the case of Public Prosecutor versus Dr. Nadasan Kanagalingam, the doctor was found guilty for carrying out abortion despite the evidence provided by the doctor that pulmonary embolism might be caused by her enlarged varicose veins. The court ruled that there was no indication that the woman's life was or would be in danger if the pregnancy was allowed to continue. Besides, abortion falls under the scope of Section 315 of the Penal Code because it is an act done with the intent to prevent a child from being born alive or cause it to due after birth.
Does abortion amount to murder in Malaysia?
As per explanation to Section 299 of the Penal Code, the life of a child is not a separate and distinct existence while it remains within the womb. Under Section 316, as soon as any part of the child has been brought forth from the womb, the child is regarded as a living human being, to cause whose death may be culpable homicide. However, some argue that the injuries to unborn children, in order to amount culpable homicide, should have been caused while the children is about to be born. Cases of miscarriage provide for the killing of fetus at an earlier stage, but that doesn't amount to culpable homicide. Further, it is also argued that the killing of an unborn child doesn't amount to murder under any of these provisions.
Here from the report, a small number of cross-sexual international study suggested that marriage was associated with higher HIV prevalence among adolescent girls, concluding that early marriage is associated with a variety of HIV vulnerabilities.
So how does HIV affect the child?
In the journal by the International Center of Research on Women, write that young women have little negotiating power in sexual behavior and practices, putting them at a greater risk of contracting reproductive and sexually transmitted infection. Under the OAPA, which in section 18, the intentional transmission of infection through consensual sexual intercourse falls within the offence of causing grievous bodily harm with intent. And under section 20 of the Act, the reckless transmission of infection through consensual sexual intercourse falls within the offence of malicious infliction of grievous bodily harm.
So how to prove if there is an intention for the sexual intercourse or consent of the deceased?
He or she must have been wronged by not being forewarned of a partner known's HIV positive status. This requirement of express knowledge is introduced into the analysis without discussion or justification, and it is by no means self-evident. Consent part of the victim is very important to be and must be included. In the cited case R and Dika 2004, the appellant was a man living with HIV. He had committed of 2 counts of causing grievous bodily harm under the section 20 of OAPA, and subsequently appealed the conviction. What remains uncertain of the Court of Appeal decision is how consent could be established. If the HIV positive partner had not disclosed their status, some may argue that consenting to unprotected sex may equal to consenting to the risk of sexually transmitted infection. However, this argument was rejected in the case of R and Kozani 2005, where a distinction was drawn between running the risk of transmission and willingly or consciously consenting to the risk of transmission of a particular infection, thus establishing that consent must be informed.
Furthermore, he could be charged under Section 12, Sub 2 of the Prevention and Control of Infectious Disease Act 1988 for spreading HIV or AIDS, which is categorized as a severe disease and may result in death. Unfortunately, research has shown that HIV or HPV patients are prone to cancers. Since the disease would endanger child bride's life, that constitutes grievous hurt as defined under Section 320 sub H. Hence, the man could be also charged for voluntary causing grievous hurt under Section 322.
Is there any diseases would be caused due to child marriage other than sexually transmitted diseases?
Yes. According to Dr. Emilia Hezrina, a family medicine specialist, pregnant teens are at high risk of facing health impacts such as postpartum depression, which cause high suicide rate, low self-esteem, and emotional troubles.
Oh, would the law criminalize male partners of child bride for causing psychological and emotional consequence on child bride?
In the Malaysian context, depression or any other psychological disease suffered by child brides constitute hurt under Section 319 of the Penal Code. This can be seen in the case of Jasrama Jamatma, where it was held that the victim who got a fright was considered to be an infirmity. So at this point, it can be perceived that psychological consequences and spread of infectious disease are both covered under the scope of hurt as defined under Section 319. Hence, male partners who spread disease or cause depression could be convicted of voluntary causing hurt under Section 321 of the Penal Code.
In addition, a study conducted by the International Center for Research on Women found that girls who married before the age of 18 were twice as likely to report being slapped, beaten, or threatened by her husband than girls who married later.
Domestic abuse is rarely a one-off incident and is the cumulative and interlinked types of abuse that have particularly damaging effect on the victim.
So what's the law in UK?
There are several possible offences for which the perpetrators can be prosecuted. This can range from murder and manslaughter, which is charged under the Criminal Justice Act, or rape under the Sexual Offences Act, through to Section 20, which is assault, and Section 47, threatening behaviour, which is battery according to OAPA. In UK, Many states define domestic violence as a distinct crime according to Domestic Violence Crime and Victims Act 2004. It extends to any hurt or injury calculated to interfere with the health or comfort of the victim, provided that it is more transient and trifling. According to Section 47 of the Criminal Justice Act 1925, provides that on a charge against wife for any offence was committed in the presence of, under a coercion of a husband. In Davis v. Johnson, the court upheld that a liberal interpretation of the Act and found it confers the rights to exclude a violent person from a home whether married or unmarried. To what extent does the Malaysian law protect the victims in domestic violence cases?
Following amendments made in Domestic Violence Act 1994 in 2011, the scope of domestic violence has become wider where it can be sexual, physical, verbal, as well as psychological.
So is domestic violence a serious issue in Malaysia?
Yes, it was revealed that a report documenting 20,000 sexual abuses cases involving Malaysian children had been hidden by the previous Barisan Nasional government for the past 10 years.
How would child marriage impact on child rights in terms of psychological harms?
It was pointed out by a former social worker for Women's Aid organization that child brides often feeling isolated from the society due to their low education level. Due to the fact that parents often choose marriage as a solution to safeguard a family's honor when facing with the pregnant teenage daughter, child brides are prone to emotional injury.
So would the male partners be penalized under Section 321 as you mentioned before for the acts of domestic violence?
Yeah, definitely. This is because physical, sexual, and psychological abuse falls within the scope of the definition of hurt under Section 319. Besides, it is also an offence for one to intentionally use force to another, knowing it to be likely cause injury, fear, or annoyance under Section 350, and the word force is defined under Section 349. In Harun versus Omar, the husband was found guilty for cruelly assaulting his wife by physically beating her. Besides, child marriage cases could start from human trafficking. How does the UK govern on this issue?
In the UK, human trafficking is governed by the Modern Slavery Act 2015. The main elements refers to the threat or use of force or any other forms of coercion, of abduction, of fraud, deception, or any other abuse of powers, of position of vulnerability, or of the giving or receiving of any payments or benefits to the consent of a person having control over another person. So the exploitation can be varied, includes domestic servitude, labor exploitation, criminal activities such as cannabis cultivation or petty street crimes, sexual exploitation, and also application of residences, including sham marriage.
As for Malaysia, the crime of human trafficking is governed by the Anti-Trafficking in Persons and Anti-Smuggling of Migrants Act. Section 14 of the Act provides that any person who traffics in person, being a child, for the purpose of exploitation commits an offence. When these young girls are forced into an early marriage, many fail to realize that the conditions that these girls are living in after their marriage life is a form of slavery. Child marriage can be said to be a form of slavery if the child did not give consent to the marriage, or the child is controlled by a husband with a sense of ownership in marriage, the child is forced to undertake domestic chores or engaged in non-consensual sexual relations, and if the child cannot realistically live or end the marriage, leading potentially to a lifetime of slavery. On the other hand, parents who receive money in return for marrying off their children will be prosecuted under Section 15 of the Act, whereby the money received is viewed as the profits from the exploitation. The issue of consent is also not applicable in this situation because Section 16 of the Act provides that consent shall not be a defence to the act of trafficking in persons. These so-called consent are usually given by children because they are unable to object to the marriage due to social or family pressure.
Is there any suggestion or reform should be done in the UK?
There is a suggestion of a reference from India which had reformed the law to prohibit the early child marriage, which is the Child Marriage Restraint Amendment Act 1978. Now raises the minimum age of the marriage to 18 years old for girls and 21 years old for boys. UK should enforce the Marriage and Civil Partnership Minimum Age Bill.
it seems that UK actually has taken the initiative to make a reform in child marriage law. What about Malaysia?
I think Malaysia should take other Muslim majority countries as role models by increasing the legal age to marry. For example, individuals are only allowed to get married at 19 in Algeria and 18 in Turkey or Bangladesh. It should be noted that religious practice should never supersede fundamental rights of a child. The Parliament should legislate the age of majority, which falls under Para 4 sub E sub 1 of the 9th schedule of the Federal Constitution. Although state legislature can make laws on Islamic personal matters relating to marriage, Para 4 sub E sub 2 states that the state legislature is not vested the power to make laws on the age of majority.
We have come to the end of this international forum. Thank you all for sharing all the laws from Malaysia, and thank you Malaysia delegates and the UK delegates.
In conclusion, our stance is that Malaysia should ban child marriages.